Please like, share, and subscribe this video to support.
2 U.S. Code Paragraph 1406, Appeal to Board. A. In general, any party aggrieved by the decision of a hearing officer under Section 1405, G, of this title may file a petition for review by the Board not later than 30 days after entry of the decision in the records of the office. B. Parties' opportunity to submit argument. The parties to the hearing upon which the decision of the hearing officer was made shall have a reasonable opportunity to be heard through written submission and, in the discretion of the Board, through oral argument. C. Standard of review. The Board shall set aside a decision of a hearing officer if the Board determines that the decision was 1. Arbitrary, capricious, an abuse of discretion, or otherwise not consistent with law. 2. Not made consistent with required procedures, or 3. Unsupported by substantial evidence. D. Record. In making determinations under subsection C, the Board shall review the whole record, or those parts of it cited by a party, and due account shall be taken of the rule of prejudicial error. E. Decision. The Board shall issue a written decision setting forth the reasons for its decision. The decision may affirm, reverse, or remand to the hearing officer for further proceedings. A decision that does not require further proceedings before a hearing officer shall be entered in the records of the office as a final decision. 2 U.S. Code Paragraph 1407, Judicial Review of Board Decisions and Enforcement. A. Jurisdiction. 1. Judicial Review. The United States Court of Appeals for the Federal Circuit shall have jurisdiction over any proceeding commenced by a petition of A. A party aggrieved by a final decision of the Board under Section 1406, E, of this title in cases arising under Part A of Subchapter 2. B. A charging individual or a respondent before the Board who files a petition under Section 1331, D, 4, of this title. C. The General Counsel or a respondent before the Board who files a petition under Section 1341, C, 5, of this title, or D. The General Counsel or a respondent before the Board who files a petition under Section 1351, C, 3, of this title. The Court of Appeals shall have exclusive jurisdiction to set aside, suspend, in whole or in part, to determine the validity of, or otherwise review the decision of the Board. 2. Enforcement. The United States Court of Appeals for the Federal Circuit shall have jurisdiction over any petition of the General Counsel, filed in the name of the office and at the direction of the Board, to enforce a final decision under Section 1405, G, or 1406, E, of this title with respect to a violation of Part A, B, C, or D of Subchapter 2. B. Procedures. 1. Respondents. A. In any proceeding commenced by a petition filed under subsection A, 1, A, or B, or filed by a party other than the General Counsel under subsection A, 1, C, or D. The office shall be named respondent, and any party before the Board may be named respondent by filing a notice of election with the court within 30 days after service of the petition. B. In any proceeding commenced by a petition filed by the General Counsel under subsection A, 1, C, or D. The prevailing party in the final decision entered under Section 1406, E, of this title shall be named respondent, and any other party before the Board may be named respondent by filing a notice of election with the court within 30 days after service of the petition. C. In any proceeding commenced by a petition filed under subsection A, 2. The party under Section 1405 or 1406 of this title that the General Counsel determines has failed to comply with the final decision under Section 1405, G, or 1406, E, of this title shall be named respondent. 2. Intervention. Any party that participated in the proceedings before the Board under Section 1406 of this title, and that was not made respondent under Paragraph 1, may intervene as of right. C. Law applicable. Chapter 158 of Title 28 shall apply to judicial review under Paragraph 1 of subsection A, except that 1. With respect to Section 2344 of Title 28, service of a petition in any proceeding in which the office is a respondent shall be on the General Counsel, rather than on the Attorney General. 2. The provisions of Section 2348 of Title 28, on the authority of the Attorney General, shall not apply. 3. The petition for review shall be filed not later than 90 days after the entry in the office of a final decision under Section 1406, E, of this title, and 4. The office shall be an agency, as that term is used in Chapter 158 of Title 28. D. Standard of review. To the extent necessary for decision in a proceeding commenced under subsection A, 1, and when presented, the court shall decide all relevant questions of law and interpret constitutional and statutory provisions. The court shall set aside a final decision of the Board if it is determined that the decision was 1. Arbitrary, capricious, an abuse of discretion, or otherwise not consistent with law. 2. Not made consistent with required procedures, or 3. Unsupported by substantial evidence. E. Record. In making determinations under subsection D, the court shall review the whole record, or those parts of it cited by a party, and due account shall be taken of the rule of prejudicial error. 2 U.S. Code Paragraph 1408, Civil Action. A. Jurisdiction. The District Courts of the United States shall have jurisdiction over any civil action commenced under Section 1401 of this title and this section by a covered employee. B. Parties. The defendant shall be the employing office alleged to have committed the violation, or in which the violation is alleged to have occurred. C. Jury trial. Any party may demand a jury trial where a jury trial would be available in an action against a private defendant under the relevant law made applicable by this chapter. In any case in which a violation of Section 1311 of this title is alleged, the court shall not inform the jury of the maximum amount of compensatory damages available under Section 1311, B.1, or 1311, B.3 of this title. D. Appearances by House Employment Counsel. 1. In general, the House Employment Counsel of the House of Representatives and any other counsel in the Office of House Employment Counsel of the House of Representatives, including any counsel specially retained by the Office of House Employment Counsel, shall be entitled, for the purpose of providing legal assistance and representation to employing offices of the House of Representatives under this chapter, to enter an appearance in any proceeding before any court of the United States or of any state or political subdivision thereof without compliance with any requirements for admission to practice before such court, except that the authorization conferred by this paragraph shall not apply with respect to the admission of any such person to practice before the United States Supreme Court. 2. House Employment Counsel defined. In this subsection, the term Office of House Employment Counsel of the House of Representatives means a. The Office of House Employment Counsel established and operating under the authority of the Clerk of the House of Representatives as of November 12, 2001. B. Any successor office to the Office of House Employment Counsel which is established after November 12, 2001, and C. Any other person authorized and directed in accordance with the rules of the House of Representatives to provide legal assistance and representation to employing offices of the House of Representatives in connection with actions brought under this subchapter. 2 U.S. Code Paragraph 1409, Judicial Review of Regulations. In any proceeding brought under Section 1407 or 1408 of this title in which the application of a regulation issued under this chapter is at issue, the court may review the validity of the regulation in accordance with the provisions of subparagraphs A through D of Section 706(2) of Title V, except that with respect to regulations approved by a joint resolution under Section 1384(c) of this title, only the provisions of Section 706(2)(b) of Title V shall apply. If the court determines that the regulation is invalid, the court shall apply, to the extent necessary and appropriate, the most relevant substantive executive agency regulation promulgated to implement the statutory provisions with respect to which the invalid regulation was issued. Except as provided in this section, the validity of regulations issued under this chapter is not subject to judicial review. 2 U.S. Code Paragraph 1410, Other Judicial Review Prohibited. Except as expressly authorized by Sections 1407, 1408, and 1409 of this title, the compliance or non-compliance with the provisions of this chapter and any action taken pursuant to this chapter shall not be subject to judicial review. 2 U.S. Code Paragraph 1411, Effect of Failure to Issue Regulations. In any proceeding under Section 1405, 1406, 1407, or 1408 of this title, except a proceeding to enforce Section 1351 of this title with respect to offices listed under Section 1351(e)(2) of this title, if the board has not issued a regulation on a matter for which this chapter requires a regulation to be issued, the hearing officer, board, or court, as the case may be, shall apply, to the extent necessary and appropriate, the most relevant substantive executive agency regulation promulgated to implement the statutory provision at issue in the proceeding. 2 U.S. Code Paragraph 1412, Expedited Review of Certain Appeals. A. In general, an appeal may be taken directly to the Supreme Court of the United States from any interlocutory or final judgment, decree, or order of a court upon the constitutionality of any provision of this chapter. B. Jurisdiction. The Supreme Court shall, if it has not previously ruled on the question, accept jurisdiction over the appeal referred to in subsection A, advance the appeal on the docket, and expedite the appeal to the greatest extent possible. 2 U.S. Code Paragraph 1413, Privileges and Immunities. The authorization to bring judicial proceedings under Sections 1405, F, 3, 1407, and 1408 of this title shall not constitute a waiver of sovereign immunity for any other purpose, or of the privileges of any senator or member of the House of Representatives under Article 1, Section 6, Clause 1 of the Constitution, or a waiver of any power of either the Senate or the House of Representatives under the Constitution, including under Article 1, Section 5, Clause 3, or under the rules of either House relating to records and information within its jurisdiction. 2 U.S. Code Paragraph 1414, Settlement. Any settlement entered into by the parties to a process described in Section 1331, 1341, 1351, or 1401 of this title shall be in writing and not become effective unless it is approved by the Executive Director. Nothing in this chapter shall affect the power of the Senate and the House of Representatives, respectively, to establish rules governing the process by which a settlement may be entered into by such House or by any employing office of such House. 2 U.S. Code Paragraph 1415, Payments. A. Awards and Settlements. Except as provided in subsection C, only funds which are appropriated to an account of the office in the Treasury of the United States for the payment of awards and settlements may be used for the payment of awards and settlements under this chapter. There are appropriated for such account such sums as may be necessary to pay such awards and settlements. Funds in the account are not available for awards and settlements involving the Government Accountability Office or the Government Publishing Office. B. Compliance. Except as provided in subsection C, there are authorized to be appropriated such sums as may be necessary for administrative, personnel, and similar expenses of employing offices which are needed to comply with this chapter. C. OSHA, accommodation, and access requirements. Funds to correct violations of Section 1311, A, 3, 1331, or 1341 of this title may be paid only from funds appropriated to the employing office or entity responsible for correcting such violations. There are authorized to be appropriated such sums as may be necessary for such funds. D. Reimbursement by members of Congress of amounts paid as settlements and awards. 1. Reimbursement required for certain violations. A. In general, subject to subparagraphs B and D. If a payment is made from the account described in subsection A for an award or settlement in connection with a claim alleging a violation described in subparagraph C, committed personally by an individual who, at the time of committing the violation, was a member of the House of Representatives, including a delegate or resident commissioner to the Congress, or a senator, the individual shall reimburse the account for the amount of the award or settlement for the claim involved. B. Conditions. In the case of an award made pursuant to a decision of a hearing officer under Section 1405 of this title, or a court in a civil action, subparagraph A, shall apply only if the hearing officer or court makes a separate finding that a violation described in subparagraph C occurred which was committed personally by an individual who, at the time of committing the violation, was a member of the House of Representatives, including a delegate or resident commissioner to the Congress, or a senator, and such individual shall reimburse the account for the amount of compensatory damages included in the award as would be available if awarded under Section 1981A, B, 3 of Title 42 irrespective of the size of the employing office. In the case of a settlement for a claim described in Section 1416, D, 3 of this title, subparagraph A shall apply only if the conditions specified in Section 1416, D, 3 of this title for requesting reimbursement are met. C. Violations described. A violation described in this subparagraph is 1. Harassment that is unlawful under Section 1311, A, or 1316, A of this title, or 2. Intimidation, reprisal, or discrimination that is unlawful under Section 1317 of this title and is taken against a covered employee because of a claim alleging a violation described in Clause 1. D. Multiple claims. If an award or settlement is made for multiple claims, some of which do not require reimbursement under this subsection, the individual described in subparagraph A shall only be required to reimburse for the amount referred to in this chapter as the reimbursable portion, that is, 1. Described in subparagraph A, subject to subparagraph B, and 2. Included in the portion of the award or settlement attributable to a claim requiring reimbursement. 2. Withholding amounts from compensation. A. Establishment of timetable and procedures by committees. For purposes of carrying out subparagraph B, the applicable committee shall establish a timetable and procedures for the withholding of amounts from the compensation of an individual who is a member of the House of Representatives or a senator. B. Deadline. The payroll administrator shall withhold from an individual's compensation and transfer to the account described in subsection A after making any deposit required under Section 8432 F of Title V, such amounts as may be necessary to reimburse the account described in subsection A for the reimbursable portion of the award or settlement described in paragraph 1. If the individual has not reimbursed the account as required under paragraph 1 prior to the expiration of the 90-day period, which begins on the date a payment is made from the account for such an award or settlement. C. Applicable committee defined. In this paragraph, the term applicable committee means 1. The Committee on House Administration of the House of Representatives, in the case of an individual who, at the time of the withholding, is a member of the House, or 2. The Committee on Rules and Administration of the Senate, in the case of an individual who, at the time of the withholding, is a senator. 3. Use of amounts in Thrift Savings Fund as source of reimbursement. A. In general, if, by the expiration of the 180-day period that begins on the date a payment is made from the account described in subsection A for an award or settlement described in paragraph 1, an individual who is subject to a reimbursement requirement of this subsection has not reimbursed the account for the entire reimbursable portion as required under paragraph 1. Withholding and transfers of amounts shall continue under paragraph 2 if the individual remains employed in the same position, and the executive director of the Federal Retirement Thrift Investment Board shall make a transfer described in subparagraph B. B. Transfers. The transfer by such executive director is a transfer from the account of the individual in the Thrift Savings Fund to the account described in subsection A of an amount equal to the amount of that reimbursable portion of the award or settlement, reduced by 1. Any amount the individual has reimbursed, taking into account any amounts withheld under paragraph 2, and 2. If the individual remains employed in the same position, any amount that the individual is scheduled to reimburse, taking into account any amounts to be withheld under the individual's timetable under paragraph 2. C. Initiation of transfer. Notwithstanding Section 8435 of Title V, the executive director described in subparagraph A shall make the transfer under subparagraph A upon receipt of a written request to the executive director from the Secretary of the Treasury in the form and manner required by the executive director. D. Coordination between payroll administrator and the executive director. The payroll administrator and the executive director described in subparagraph A shall carry out this paragraph in a manner that ensures the coordination of the withholding and transferring of amounts under this paragraph, in accordance with regulations promulgated by the board under Section 1383 of this title and such executive director. 4. Administrative wage garnishment or other collection of wages from a subsequent position. A. Individual subject to garnishment or other collection. Subparagraph B shall apply to an individual who is subject to a reimbursement requirement of this subsection if, at any time after the expiration of the 270-day period that begins on the date a payment is made from the account described in subsection A for an award or settlement described in paragraph 1, the individual 1. Has not reimbursed the account for the entire reimbursable portion as required under paragraph 1 through withholdings or transfers under paragraphs 2 and 3. 2. Is not serving in a position as a member of the House of Representatives or a senator, and 3. Is employed in a subsequent non-federal position. B. Garnishment or other collection of wages. On the expiration of that 270-day period, the amount of the reimbursable portion of an award or settlement described in paragraph 1, reduced by any amount the individual has reimbursed, taking into account any amounts withheld or transferred under paragraph 2 or 3, shall be treated as a claim of the United States and transferred to the Secretary of the Treasury for collection. Upon that transfer, the Secretary of the Treasury shall collect the claim, in accordance with Section 3711 of Title 31, including by administrative wage garnishment of the wages of the individual described in subparagraph A from the position described in subparagraph A. 3. The Secretary of the Treasury shall transfer the collected amount to the account described in subsection A. 5. Notification to Office of Personnel Management and Secretary of the Treasury. A. Individual subject to annuity or Social Security withholding. Subparagraph B shall apply to an individual subject to a reimbursement requirement of this subsection if, at any time after the expiration of the 270-day period described in paragraph 4A, the individual 1. Has not served in a position as a member of the House of Representatives or a senator during the preceding 90 days, and 2. Is not employed in a subsequent non-federal position. B. Annuity or Social Security withholding. If, at any time after the 270-day period described in paragraph 4A, the individual described in subparagraph A has not reimbursed the account described in subsection A for the entire reimbursable portion of the award or settlement described in paragraph 1, as determined by the Secretary of the Treasury through withholdings, transfers, or collections under paragraphs 2 through 4, the Secretary of the Treasury, after consultation with the payroll administrator, 1. Shall notify the Director of the Office of Personnel Management, who shall take such actions as the Director considers appropriate to withhold from any annuity payable to the individual under Chapter 83 or Chapter 84 of Title 5 and transfer to the account described in subsection A such amounts as may be necessary to reimburse the account for the remainder of the reimbursable portion of an award or settlement described in paragraph 1. And 2. Shall, if necessary, notwithstanding Section 207 of the Social Security Act, 42 U.S.C. 407, take such actions as the Secretary of the Treasury considers appropriate to withhold from any payment to the individual under Title II of the Social Security Act, 42 U.S.C. 401 etc., and transfer to the account described in subsection A such amounts as may be necessary to reimburse the account for the remainder of the reimbursable portion of an award or settlement described in paragraph 1. 6. Coordination between OPM and Treasury. The Director of the Office of Personnel Management and the Secretary of the Treasury shall carry out paragraph 5 in a manner that ensures the coordination of the withholding and transferring of amounts under such paragraph, in accordance with regulations promulgated by the Director and the Secretary. 7. Certification. Once the Executive Director determines that an individual who is subject to a reimbursement requirement of this subsection has reimbursed the account described in subsection A for the entire reimbursable portion, the Executive Director shall prepare a certification that the individual has completed that reimbursement and submit the certification to A. The Committees on House Administration and Ethics of the House of Representatives, in the case of an individual who, at the time of committing the act involved, was a member of the House of Representatives, including a delegate or resident commissioner to the Congress, and B. The Select Committee on Ethics of the Senate, in the case of an individual who, at the time of committing the act involved, was a senator. 8. Right to intervene. An individual who is subject to a reimbursement requirement of this subsection shall have the unconditional right to intervene in any mediation, hearing, or civil action under this subchapter to protect the interests of the individual in the determination of whether an award or settlement described in paragraph 1 should be made, and the amount of any such award or settlement, except that nothing in this paragraph may be construed to require the covered employee who filed the claim to be deposed by counsel for the individual in a deposition that is separate from any other deposition taken from the employee in connection with the hearing or civil action. 9. Definitions. In this subsection, A. Non-federal position. The term non-federal position means a position other than the position of an employee, as defined in Section 2105A of Title V. B. Payroll administrator. The term payroll administrator means 1. In the case of an individual who is a member of the House of Representatives, the Chief Administrative Officer of the House of Representatives, or an employee of the Office of the Chief Administrative Officer who is designated by the Chief Administrative Officer to carry out this subsection, or 2. In the case of an individual who is a senator, the Secretary of the Senate, or an employee of the office of the Secretary of the Senate who is designated by the Secretary to carry out this subsection. E. Reimbursement by employing offices. 1. Notification of payments made from account. As soon as practicable after the executive director is made aware that a payment of an award or settlement under this chapter has been made from the account described in subsection A, in connection with a claim alleging a violation of Section 1311A or 1316A of this title by an employing office, other than an employing office of the House of Representatives or an employing office of the Senate, the executive director shall notify the head of the employing office that the payment has been made and shall include in the notification a statement of the amount of the payment. 2. Reimbursement by office. Not later than 180 days after receiving a notification from the executive director under paragraph 1. The head of the employing office involved shall transfer to the account described in subsection A, out of any funds available for operating expenses of the office, a payment equal to the amount specified in the notification. 3. Timetable and procedures for reimbursement. The head of an employing office shall transfer a payment under paragraph 2, in accordance with such timetable and procedures as may be established under regulations promulgated by the office.